Big criminal law news in Canada today. The Supreme Court of Canada has struck down the mandatory minimum sentence in the criminal code for CP offenses, specifically possessing it and accessing it. And the reason for this, you might think, hey, wait a minute, these are terrible offenses. And that's what the Supreme Court of Canada says. But what the Supreme Court of Canada reasoned was that because the offense itself of possessing it or accessing it captures a broad range of conduct, the mandatory minimum sentence doesn't make sense in the circumstances of some very easily, reasonably foreseeable circumstances, one of which is that an 18-year-old receives a spicy message from their 17-year-old girlfriend, saves it on their phone, and accesses it. The 18-year-old and the 17-year-old are in a consensual relationship under Canadian law. The 18-year-old and the 17-year-old have both voluntarily chosen to do this thing, but it is technically illegal. And the court says, yes, this is conduct that does need to be denounced, because it is still CP nevertheless, but does that person deserve the same mandatory minimum sentence as somebody who's going online and downloading, very exploitative material? Absolutely not. So that's why the sentence was struck down. But this decision is also a bigger message, especially in this time where there's this huge hue and cry in our justice system for stronger penalties, less bail, greater mandatory minimums, where the government has tabled legislation that would make sentencing tougher in some circumstances. This is a message from the Supreme Court of Canada that you can't create tough mandatory sentences unless you really consider that absolutely nobody who doesn't deserve those sentences could be captured under that sentencing regime, because otherwise that makes the sentence constitutionally vulnerable. And the court even talks about constitutional vulnerability when it comes to mandatory minimum sentences, and talks about how the constitutional vulnerability is directly tied to the way in which a mandatory minimum sentence captures a broad range of conduct. Think about for impaired driving offenses, for example. If you're sleeping in your vehicle, which is, as we've discussed, the criminal offense of impaired operation of a motor vehicle, because that's care and control, if you're sleeping in the vehicle, you get the same mandatory minimum of sentence as somebody who crashes their car into multiple parked cars and, deliberately got behind the wheel knowing that they were impaired. That's the same mandatory minimum, and yet one variation of the conduct most people are not that particularly bothered by, whereas the other one, everybody's bothered by. This is why these mandatory minimum sentences are a bad idea. The government has repeatedly been told by the Supreme Court of Canada that if you're going to craft mandatory minimum sentences, you'd better be very sure that they're not going to capture anybody, a hypothetical offender or a reasonable possibility of the application of the law that is going to make the sentence appear grossly disproportionate. And so that's why the CP mandatory minimum was struck down by the Supreme Court of Canada today.